This is courtroom 1. This is the first session for Thursday, June the 20th, 2019. Judge Kirkland presiding, appearing on behalf of the Office of the State Attorney.
Kathy Kennedy Swanson.
Thank you. And appearing on behalf of the Office of the Public Defender.
Brian Wynn.
Thank you. So we'll start with Christopher Robert Cooper. All right. There is probable cause to hold him. His bond is $5,200 for burglary, and his first appearance will be rescheduled for tomorrow morning. Desmond Howard Derrick.
He refused. Your Honor, we'd asked that this case not be rolled again. He refused yesterday as well. He had a mental health reset on 6/18.
All right. The following action will be taken by me at this time. I appoint the public defender to represent him. It's in 2019 MM 5084. He is charged with misdemeanor charges, petty theft, and trespass after warning. But this is the second refusal, and it would be in his best interest to have an attorney. Perhaps it can be determined why he's refusing, because it's in his best interest to come, because it's the type of case that might be resolvable at first appearances. Not to be reset until requested by counsel.
We'd ask us for no return since it is a petty theft.
And no return to that location.
Thank you, Your Honor.
And State, would you?
Raymond Beckwith.
Yes.
I'm Judge Kirkland. I'm reviewing your paperwork today, Mr. Beckwith. The arrest affidavit is from yesterday. The arrest took place at 8296 South Orange Blossom Trail, so that sounds as if it would be south of Sand Lake Road on the trail. The charge is failure to report, and it's indicated here that you were actually out on bond on the same type of charge from an earlier date. That prior case is 2019 CF 7734, assigned to Division 15. The public defender is appointed to represent you today on the new charge. It's Division 14, so your attorney's standing next to you. It comes to me as a no bond, but I will be setting the conditions of release. What's the state's position concerning the new charge and the prior case?
Your Honor, we'll ask for a $7,500 bond on this case because he's out on bond, no action on the out on bond case.
All right. I do find that that would be appropriate. I take no action on the prior case, and the hold that the jail has on that prior case is lifted at this time, but there is a new case with a new bond, and the bond set for this second case is now set at $7,500. One other matter needs to be, I need to remind you of something. Your address right now is where you are located, and so as soon as, if you bond out or the case is resolved, as soon as you leave, you're now establishing a new address. So you must report within 24 hours of leaving the jail.
Okay.
Yeah, needs more power. This is Shannon Rochelle Caldwell.
Yes, sir.
This is a very thick file, and so I'm going to go through these in the most practical way. The first matter is a warrant It refers to a date between April the 21st and April the 24th of 2019, receiving stolen property and receiving money from a pawnbroker with false verification. Bond set at $2,500 and $1,000 for a total of $3,500. No contact with the victims and no return to the scene. The public defender is appointed to represent you on that warrant, case number 2019 CF 8542, Division 20. Division 20. The second warrant is case number 2019 CF 8543. I appoint the public defender to represent you in Division 10 on that case, and it's for the same dates: dealing stolen property, $2,500 bond, and fraudulent pawn shop statute, $1,000 for a total of $3,500 in that case. The judge in that case ordered no contact with the victim and no return to the scene. The next warrant is same charges, same dates. It's Division 14, same bonds. The next warrant is Division 20, same charges, same dates, same bonds. So there are now 4 of those that I've reviewed. The 5th case is a warrant, and it's assigned to Division 11. The same 2 charges, same 2 dates. So the public defender is appointed in Division 11. And the final case is Division 19. It has 1 charge. That warrant refers to the same dates between April the 21st and April the 24th. But the 1 charge is entitled grand theft, more than $300 but less than $5,000. It's a felony charge having a bond of $2,500. But it also has a no contact and no return to the scene. So in each case, there's a public defender appointed, and there's one further complication. It is indicated that you were out on bond on case number 2019 CF 4071. The charge, fraudulent use of a credit card theft, and petty theft. The public defender represents you already in that case in Division 17. And you were released on March the 24th. So it is therefore a situation where these new warrants come from a month later, while you were out, where you had been released on that prior case. What is the state's position concerning that March case that has 3 charges involving credit cards?
We'll ask the bond be revoked on the out-on-bond case, Your Honor.
The following would be appropriate for that case. I do revoke that release for case number 2019 CF 4071. You will need to talk with your public defender in Division 17. I do find that you are to be held without bond to see the judge in Division 17. That judge, of course, can set new bond or can hold you without bond. The judge will have your file and will be able to look at the new charges and decide what's appropriate for you. But my obligation in looking at these new charges and the prior case, I should hold you without bond until the judge in Division 17 is able to review the whole matter. But you have the public defender on each and every charge. John Randall Sanders.
Yes, sir.
This is a warrant arrest affidavit. The original is a capias. That means to me that information has been filed against you by the state attorney's office charging you with driving while license suspended with 2 prior convictions, which is a felony charge, and driving while license permanently revoked, a felony charge. The reason for the capias being issued, it states, is that you failed to appear for a pretrial conference on May the 15th of 2019. The judge in Division 22 ordered a bond of $2,500 on each of the 2 charges, so your total bond today is $5,000. I believe that you have the public defender representing you on those charges. So if you cannot meet that new bond of $5,000, talk to your attorney about getting a hearing in front of the judge in Division 22. That judge has set the bond and can make a decision as to whether it's appropriate to reduce it or take other action. But I cannot do that today. I have to simply advise you that you need to post a bond of $5,000 to secure your release on these 2 charges.
Okay.
Russell Wayne Carey.
Yes, sir.
This is a charge of battery, but it's charged as a felony charge due to the allegation that there's been a prior battery conviction. The public defender is appointed to represent you in Division 10, and this charge comes from yesterday at 1532 Formosa Avenue. You can post a bond of $2,500 with a condition of no contact with the person that is listed as the victim, Kathleen Meany, while this case is pending. So stay in touch with your attorney in Division 10.
We'd also ask for no weapons and firearms.
You're not to be in possession of any weapon, including a firearm, while the case is pending.
I understand.
Roosevelt Davis.
Yes, sir.
This is a warrant that refers to a date of December the 5th of 2018. So this is from about 6 months ago. The charges are in Division 20, and I do not have any paperwork from you concerning an attorney. Are you planning to hire a private attorney on these charges?
No, sir, I want to go pro se. No, sir, I want to go pro se.
All right. You have the right to do that, but I would recommend to you that you either hire a private attorney, or if you cannot afford one, request a public defender, because these are very serious felony charges. And it would help you a lot to have the assistance of an attorney. But you have to make that decision. No one can make you request an attorney. These charges are listed as, number one, a burglary of a structure with a bond of $3,500. Count 2, petty theft with 2 prior convictions of felony with a bond of $1,000. And then criminal mischief, misdemeanor, $500. So it indicates the total bond is $5,000 on this warrant. The judge has ordered, Judge Young determined that the total bond should be $5,000 and had the following additional conditions: no return to the location of the alleged offense, no contact with the victim or the victim's representatives. That location is listed as Innovative Electronics, 2001 South Orange Avenue. You can now bond out on a $5,000 bond with those additional conditions. At any point, you can request a public defender. At your next hearing, if you decided it would be best to ask for the public defender, you can do so at your arraignment. This is Peterson, Desravines?
No.
All right. He's being held because of prior cases in any event, so this is rescheduled for tomorrow morning for first appearances. Jordan Gideon.
Yes, sir.
There are several matters here. The first arrest affidavit is for burglary of an occupied dwelling, 1017 Appleton Avenue in Orange County. The bond has been set at $5,000. I've appointed the public defender to represent you in Division 12 on that case. So it's $5,000 and no return to 1017 Appleton Avenue while the case is pending. No contact with anyone that's named or referred to as a victim or a witness. The second matter is an arrest affidavit for fleeing and attempting to elude. It comes to me as a no bond status, and that's in Division 19. The public defender to represent you, appointed to represent you in Division 19. I will return to that. It's no bond, but I'll set the conditions when I come back to that case. The third arrest affidavit is grand theft, third degree of a motor vehicle, bond $1,000, and it's in Division 10. And that comes from 3626 Rosswood Drive. That case number is 2019 CF 8818. The next arrest affidavit is aggravated assault on a law enforcement officer with a motor vehicle. That's in Division 15. And that also comes from 3626 Rosswood Drive. And there will be no contact with anyone that's named as a passenger in the vehicle, a victim or a witness, or arresting officer or deputy. The next case is attempted burglary of a conveyance from yesterday at Rowlron Court and Pershing Avenue. And the public defender is appointed to represent you in Division 17 in that case. The bond is $1,000. That has to do with where the arrest was, but the event that's the subject of the case is also 3626 Rosswood Drive, as was the address on the last two affidavits before that. The next case is an arrest affidavit in Division 20, attempted burglary of a conveyance, and that's also from the same location. Bond is $1,000. It's Division 20. Next arrest affidavit is in Division 15, burglary of a conveyance having the bond of $3,500. The same location. So some of those bonds are going to change because, or they may change, if there is a situation where if they could have been different counts on one affidavit as opposed to different affidavits. The first thing I'll return to, though, is the fleeing charge. It comes to me as a no bond, and I have to set the bond in that case based upon the statutory elements to be considered. Were you driving a motor vehicle? Did you endanger yourself or a passenger in the vehicle or other drivers or pedestrians? Was there a crash? Was there excessive speed or running a red light or running stop signs? Were you leaving a more serious offense? Have you had a conviction in the past of fleeing? And what is your general prior criminal history? What's the state's position as far as a request for bond in this case?
$3,500.
All right. From my analysis of the various charges involved and your prior history, I find that $3,500 is an appropriate bond for this one fleeing charge. And then the second issue is, should some of these bonds be reduced to $150 because they are, in fact, could have been combined into one affidavit?
Yes, Your Honor.
All right. I'm going to go through these individually, and all of the cases that come from one address will have that effect. And so that fleeing case is a standalone, because that is in the area of Bumby and Pershing, which is that's a four-way stop sign in the middle of a residential area and really is not connected by address to the other ones. So it will stand alone. But the cases that are connected to 3626 Rosswood Drive will now have the following changes. Case number 2019 CF 8818. That bond, which is listed at $1,000, will now be $150 instead. The burglar of a dwelling that's 2019 8816 will remain at $5,000. That one is from 1017 Appleton Avenue. The aggravated assault with a motor vehicle will remain at $5,000 because it is the principal charge from 3626 Rosswood Drive. The other charges from that location will now be $150, and they are as follows. Case number 2019 CF 8820 is now $150. It's the attempted burglary of a conveyance. Next case is 2019-8821, attempted burglary of a conveyance. That bond is now $150. The burglary of a dwelling, the burglary of a conveyance, 2019-8822, is now $150, because I've already set a bond of $5,000 for the burglary of the dwelling. So that now takes care of our rules as far as setting bond. They each have the appropriate bond now, and we'll have to figure out what the total is, but you have the public defender on each and every one of these cases, and each of those has a no return to that location and no contact with anyone that's named or referred to as a victim or a witness. Keith Gribble. Keith Andrew Gribble. Thank you. Eddie Haiti. This is a capias from Division 14. Failure to appear. The original charges: fleeing, attempting to elude. Second charge, reckless driving, failure to appear for arraignment on June the 11th. Release was revoked by that judge in Division 14, and you're being held without bond till you see that judge in Division 14. Do you have an attorney on those charges?
Yes, sir.
Is that a private attorney or a public defender?
Private, sir.
Private attorney, all right. You have a new arrest affidavit from yesterday, and that's at First Baptist Church in South John Young Parkway. And the case begins at Columbia Street in South John Young Parkway, and it travels through an area. Count 1 is possession of cannabis with intent to sell or deliver with a weapon. It lists at no bond, and we'll return to that in a moment. Count 2 is a felony charge of possession of cannabis more than 20 grams, bond $1,000. The cases are in Division 16. What's the state's position concerning bond for that first charge of possession with intent with a weapon?
Your Honor.
And, Your Honor,
It appears that the facts of the case is that it was a firearm in the glove compartment of the vehicle which was stopped.
I believe when I spoke to defense, and they can correct me if I'm wrong, prior to court, it was gonna be, we would find PC for possession with a weapon, not with intent to sell and deliver.
yes, that's correct.
Is that correct?
Yeah.
State has noted to like $5,000 bond as to count 1.
All right. The appropriate bond for count 1 will be $5,000, and count 2 will be a bond of $150. So the total is $5,150. But you are being held without bond till you see on the prior, because of the prior capias, until you see the judge in Division 14. So you want to contact your attorney to get a hearing in front of that judge in Division 14. next case is Melvin Lewis Howard. This is an arrest affidavit that has 3 charges, and the arrest took place here at the jail, so it refers to an earlier matter. The date referred to is June the 10th, so it's from a little over a week ago, at 403 West Kennedy Boulevard in Eatonville, Florida. Count 1, aggravated assault with a deadly weapon but without intent to kill, so it has a bond. The bond is $5,000. Count 2 is a misdemeanor obstruction of resisting an officer without violence, bond 100. Count 3 is damaging property, misdemeanor, having a bond of 100. So your total bond is $5,200 from that case from June the 10th. It refers to the Discount Cigar Store in Eatonville concerning a disturbance. And the arrest has now been made at the jail concerning that case. So there are the following additional conditions, and I do appoint the public defender to represent you in Division 19. Those additional conditions would be have no contact with John Fitzgerald Washington, Mohammed Asim, or Detective Lampkin of the Eatonville Police Department. Those first 2 are either witnesses or victims as listed in the affidavit. The public defender does represent you, and you can now bond out on these charges.
And Your Honor, we had a probable cause challenge to the aggravated assault with a deadly weapon.
All right, you can proceed.
With regard to that count, at the time of the alleged assault, the alleged crime was over with, and the defendant was allegedly leaving the scene, and he was chased out of the building by the employee who was wielding a weapon himself, a large wooden stick. And we would contend that at that time, the defendant picked up a, well, it's alleged that he picked up a rock, and we would allege that he picked up that rock in an act of self-defense. When you are given the prospect of great bodily injury, you're allowed to reciprocate in a manner that is equal in force. So we would argue at that time he was acting in self-defense with regards to the aggravated assault.
And I make no ruling today having to do with what facts are to be given weight, but when I look at a set of facts from an arrest affidavit, if it appears to me that essentially it is a self-defense, or if there's a dispute as to what actually happened, those are not matters that can be taken into consideration to any great extent at first appearances. I have to, after reviewing this, make a determination that there's probable cause or not based upon the allegations, and I find that there is probable cause, and Mr. Howard may very well be able to prevail at a motion before the judge in Division 19 by that judge hearing sworn testimony and determining that it should be a different charge. What's the state's position concerning the issue of whether there's probable cause, or should there be a charge of a lesser felony rather than the one that's been charged?
Your Honor, state would believe that there are 2 incidences where he could have been charged with aggravated assault. The second is with the stick, the stick and the stone. I do believe that since he was the aggressor and was already breaking things up in the store, I don't believe that self-defense would apply at this point. However, Your Honor, if you look at the beginning of the affidavit where it talks about he was throwing the alcohol towards the glass, and glass got on the victim, that could be another aggravated assault at that time too.
All right. So I'm indicating that, that Mr. Howard may very well have some facts to assist him later on in the case, but I believe at first appearances, I am to hold him on the facts as have been laid out in the affidavit, as well as the total bond is appropriate of $5,200.
Okay, thank you.
This is Willie Sharon. This is a warrant that comes from Division 12. I've appointed the public defender to represent you in Division 12. It is a capias, but it's not a failure to appear of any kind. It's simply the beginning of a case. It states that it's a probable cause order. That means that the state attorney has reviewed facts and has filed an information against you, and so you're now being advised of the beginning of this case. The charge listed as possession of a firearm by a convicted felon, and the bond has been set at $5,000. The information is case number 18 CF 16928. It alleges that you, on or about the first day of June 2018, so this is from a year ago, that you owned or had in your care, custody, possession, or control a firearm, to wit, a handgun, and that you had been previously convicted on May the 17th of 2010 in Circuit Court of the 9th Judicial Circuit, that's here in Orange County, a felony dealing in stolen property, and therefore that is a new felony. And so you have the public defender, and you can now bond out on a $5,000 bond. And it would follow naturally that there's a condition of not to be in possession of any weapon, including a firearm, while this case is pending. Jason Michael DeLeo. This is an arrest affidavit from Orange County. It's a county ordinance violation of soliciting without a permit, Vineland Road and State Road 535.
1 second, John.
Mr. Nguyen, the offer is adjudication 3 days.
And is it 2 days, does he have?
Yes.
It's case number 19CO701. You are Jason Michael DeLeo?
Yes, Your Honor.
All right. And the charge is soliciting without a permit. It's a county ordinance violation. And the facts of the case, the deputy indicated that you felt like you were told you didn't need to have a permit to do that. But it is, in fact, a requirement. And so I'm going to ask whether, on behalf of the county, there's an offer to resolve this case at first appearances.
Adjudication 3 days.
Okay, so you have not requested the public defender, but you can talk to the attorney that's next to you about what your options are. One is you can bond out. If you're going to contest the case, it's $250 bond. Or if you decide to resolve the case by entering a plea, it'll be a sentence of 3 days, credit for 2. You'll be released later on today.
I'll plead out, sir.
All right? What is your full legal name
Jason Michael DeLeo,
and your date of birth?
5/10/79.
How do you plead to the county ordinance violation of soliciting without a permit?
Guilty.
Okay. And do you have a permanent residence address in Orange County?
Actually, I'm not from Orange County. I live in an RV, so I go from like Claremont, because there's 1,000 trails there, anything that's 1,000 trails.
Okay.
But I do have a mailing address in Manatee.
Okay, and you do live in an RV right now?
Yes, Your Honor.
All right. I accept your plea at this time. You did read and sign your plea form?
Yes, sir.
And do you have any questions you want to ask me about this case?
No, sir.
Okay. Now, part of the reason for this kind of case is for your protection. That's a huge intersection, and people get run over all the time walking around, depending upon whether it's day or night and how busy. But it's a very, very busy, very huge intersection. So that's part of the reason for that. But it's also another reason is that some people can't tell whether somebody's asking for money or demanding money. So other kinds of tragedies occur when somebody's actually taking money from people, without their offering it. So it is an adjudication, 3 days credit for 2. You'll be released later on today. I'll order you not to go back to that location. And your court costs, you will have 350 days from today to pay the costs.
Thank you, sir.
Joe Andrews,
Yes, Your Honor.
this is an arrest affidavit from yesterday. It has 3 charges. It's Orlando Police Department. Count 1 is a felony charge of attempted, no, it's a first-degree misdemeanor charge of attempted destruction of evidence, bond $500. Count 2, sanitary nuisance. That's a $100 bond, an open container, $100 bond, total bond $700. The public defender is appointed to represent you in Division A. These charges come from Central and the Trail from yesterday afternoon. Is this a case that can be resolved at first appearances?
Yes, Your Honor, adjudication 4 days.
Okay.
Yes.
And, Your Honor, Mr. Andrews will enter a plea of no contest.
All right. What is your full legal name?
Joe Andrews,
Date of birth?
7/29/73.
Okay. The first charge is attempted destruction of evidence. How do you plead to that charge?
No contest.
The second charge is sanitary nuisance, having to do with making a mess in the back seat of the patrol car. How do you plead to that charge?
No contest.
And the third charge is having an open container of alcohol. How do you plead to that charge?
No contest.
Did you, in fact, sign and read your plea form?
Yes, Your Honor.
Do you have any questions you want to ask me about these charges or the facts of the case, the pleas that you're entering, or the proposed sentence? Any question you want to ask me?
Questions you want to ask?
No, sir.
And have you had enough time to decide what's best for you to do today?
Yes, sir.
And are you satisfied with your attorney?
Yes, sir.
I accept the pleas at this time. You're adjudicated guilty on each charge, and you are sentenced to 4 days, credit for 2 on each one, running concurrently, that is at the same time. So ordinarily, you'd be released tomorrow on these charges.
Yes, sir.
I will order that you not return to the intersection of Central and Orange Blossom Trail during the next 179 days. Your court costs will be placed into a civil judgment.
Yes, Your Honor.
All right. Kareen Dorset. This is a charge of trespass after warning in a conveyance. It's from 878 South Ivy Lane.
Mr. Nguyen, will withhold credit for time served.
Now,
No return.
I believe that there's an inconsistency between the allegations contained in the narrative and the charge itself. The facts in the narrative have her not leaving a structure, and that being, let's see, I think it's a grocery store, the meat market, 878 South Ivy Lane. So the charge should be trespass after warning in a structure.
Yes, Your Honor.
All right. And I do appoint the public defender to represent her. Is there an offer to resolve this case?
Yes, Your Honor, withhold credit for time served, no return.
And Your Honor, she's going to enter a plea of no contest at this time.
What is your full legal name
Carlene Doors,
and your date of birth?
02/15/1991.
The charge before me today is trespass after warning in a structure from yesterday at 878 South Ivy Lane, which is the meat market. The arrest having taken place at 4420 Gore. How do you plead to that charge?
No contest.
Did you read and sign your plea form?
Yes, sir.
Do you have any questions you want to ask me about this charge?
No, sir.
Are you satisfied with your attorney?
Yes, sir.
Did you have enough time to decide what's best for you to do today? Or do you need more time to think about whether you want to enter a plea or not?
No, sir.
I'll accept the plea at this time. You're adjudicated guilty of that
It was a with.
first-degree misdemeanor. The sentence is a withhold of adjudication, time served. It's 2 days, credit for 2 days served, but I order you not to return to the meat market,
Yes, sir.
878 South Ivy Lane. The court costs, that no return is during the next 350 days, and you have the same 350 days to pay the court costs.
Yes, sir.
William L. Johnson.
Yes.
This is a first-degree misdemeanor from yesterday. The charge is possession of drug paraphernalia. It's on West South Street and Lime Avenue. Mr. Johnson represents himself. Is there an offer by the state to resolve this case today?
State has no objection to a ROR or credit for time served.
Okay. You'll need to decide what's best for you. If you feel it's best for you to contest the case, there's no objection from the state for me to release you without you having to post bond.
Yes.
But from that point on, you need to make sure you make each and every hearing,
Yes.
because the judge will put you back in jail on a no bond if you fail to show up.
Yes.
On the other hand, if you want to resolve the case today and you enter a plea, it will be time served, but there'll be an adjudication for this charge of possession of drug paraphernalia. What do you think is best for you to do?
I'd like to solve the case today.
All right. You'll need to read and sign your plea form at this time. What's your full legal name?
William Lewis Johnson,
And how do you spell your middle name?
Lous,
Thank you. Your date of birth?
6/18/68.
How do you plead to the charge of drug paraphernalia?
No contest.
Did you read and sign your plea form?
Yes.
Do you have any questions you want to ask me about this case?
No.
I'll accept the plea at this time. You're adjudicated guilty of possession of drug paraphernalia, a first-degree misdemeanor. It is 2 days, credit for 2 days served. You'll be released later on today. I order you not to return to that location of West South Street and Lime Avenue during the next 350 days. And your court costs will be reduced to a civil judgment.
Thank you.
Hey, y'all. How are you?
Thank you. This is State of Florida against
How are you?
Ali.
Yes, sir. It's L. The L is my capital L is space. It's not my middle name.
All right.
Yeah, I just want to verify that, clarify that. Yeah, verify that. Thank you, sir. Okay.
What would be helpful would be if this case is resolved, write your name the way it should be.
Yes, sir.
on-
Yes,
on the-
sir.
On the paperwork.
Yes, sir.
The charge is resisting an officer without violence from Pinecrest and Cheyenne Avenue
Yes, sir.
from yesterday. Is this a case that the state can make an offer to resolve the case today?
No, Your Honor.
All right.
Yes, sir.
Do you think it would be best for you to be assisted by the public defender in this case?
No, sir. No,
Why not?
thank you.
Why not?
I apologize to the officer yesterday that I saw it. I ran from him from resisting arrest, and he said
I'll
just
instruct the defendant that he may
He-
not want to talk about the facts of the case,
Yeah,
as everything is
he-
being recorded.
Yeah.
Yes.
It would be best for you not to get into the facts of the case,
yes, sir.
but since the state has not made an offer today,
Yes, sir.
you will be here in the jail until the case is resolved. Do you think you're going to be able to post a $500 bond?
No, sir.
Okay.
Yeah.
Then it would be even more important that you have the public defender to assist you.
No, sir. Yes, please. I don't need no public defender. Yeah, I think I'm okay. Yeah.
Only you can decide that, but I'm simply advising you that I don't recall a case
Thank
where
you,
the
sir.
person did better without an attorney than with the assistance of the public
Yes, sir.
defender.
Yeah, I think it just. Sorry, I talked too loud. I think it just resisting arrest, so I don't think I really need a public defender for that.
Okay, that's for you to
Such a
decide.
small case.
At your next hearing,
Yes, sir.
which will be about a month from now.
Thank you, ma'am. Yeah. Yes, sir.
You're going to be here in the jail for the next month. You
Yeah,
understand
that's
that?
fine. Yes, sir. I accept that. Yeah.
Okay.
They misspelled my name, so I just want to clarify that, you know.
That's why I want you to write down I want you to write down on a piece of paper
sir?
that I'll have
Yeah.
the way your name should be
Yes, sir. Yeah.
done. So, your last name is spelled how?
L-E. Yes, sir. Thank you.
Okay. And your first name is H-A,
It's H-A space and capital L.
and that's all one name?
That's one name.
Okay. That is actually the way it is listed on the arrest affidavit, and so, it's what I would call a distinction without a difference. Since it reads the same way you just wrote it out, it'll work fine.
Yes.
All right.
Thank you so much.
But if you change your mind, you should, in my opinion, you ought to talk with the public defender about the case,
Yes.
because it might be resolvable
Yes. Thank you. Yeah.
right away.
Yes.
I mean, at some point, okay?
Thank you.
Charlene Martin? This is a charge of petty theft. It's retail theft at 10500 West Colonial Drive. And that's a Walmart store, west of John Young Parkway. In the city of Ocoee. The public defender represents you on that charge. Is this a case that can be resolved at first appearances?
No, Your Honor.
You can now bond out on a bond of $250. No return to the Walmart store at 10500 West Colonial Drive while the case is pending. Bruce Owsley. This is a charge of petty theft from the same time and place. From yesterday at the Walmart, 10500 West Colonial Drive in Ocoee. The public defender is appointed to represent you in Division A. Your bond is $250. You can now bond out and no return to that Walmart while the case is pending.
Ross, spare time served.
Alice Marie Ross. This is a charge of possession of drug paraphernalia. It's a first-degree misdemeanor from yesterday at Lime and West South Street. And I believe I saw the other person that was involved with this arrest. There is a second matter, and that is open container of alcohol, a city ordinance violation. The public defender is appointed to represent you on both matters. That city ordinance violation has a case number now. It's 19MO1170. Is the state and the city making an offer to resolve these cases at first appearances?
Adjudication credit for time served.
Okay, I want you to talk with your attorney about whether it's best for you to resolve them today.
Yes. Yes, Mom. Thank you. Thank you. Yes. Thank you, Your Honor.
What is your full legal name
My name is Alice Marie Ross,
and your date of birth?
3467.
There is a charge entitled possession of drug paraphernalia, which is a first-degree misdemeanor, a state charge. How do you plead to that charge?
Yes, sir. Yes.
On the charge of having an open container of alcohol, a city ordinance violation, how do you plead?
Yes. No contest on the cause of the bill 1 month.
And was your plea to the misdemeanor of drug paraphernalia no contest?
Yeah, he's no contest. Yes.
All right. And did you read and understand your plea form?
Yes.
Did you have enough time to discuss your options with your public defender?
Yes.
Are you satisfied with your attorney?
Yes.
I accept the pleas on those two charges. And the offer from the state and the city was to be a time served, is that correct?
Yes, Your Honor.
So it is 2 days, credit for 2 days on each of the two charges, and they are running concurrently. That is, at the same time, you'll be released later on today. And you have one court cost, and those court costs go into a civil judgment at this time.
Okay. Thank you.
Doesn't recognize me. Daniel Velasquez?
Yes.
This is a 2-count arrest affidavit from yesterday. Count 1 is loitering or prowling. Count 2, resisting an officer without violence. Those are first-degree misdemeanors. The total bond is appropriately, the loitering or prowling should be a bond of $500, and the bond on the resisting without violence should be a $100 bond. For your total bond is $600, as set by me today. The public defender is appointed to represent you on these charges. The address is 1 Jeff Fuquay Boulevard, which is the address of the airport. And in the contents of the narrative, it indicates it was the store manager at the Finish Line store at the airport.
We ask that he doesn't return unless he has a valid ticket.
All right, so you do have a $600 bond, no return to the Orlando International McCoy Airport unless you have a valid ticket that indicates you are using the airport for transportation out of Orlando. You can now bond out. John Bradley Guthman. Seminole County seeks your return. This is a warrant from Seminole County. It indicates it was for grand theft of a motor vehicle. No bond because it's a violation of probation matter. If you have no Orange County cases, you'll be transported over there They should pick you up within 24 hours of being notified, and you'll go to the criminal court building in Southport part of Seminole County to see a judge there for your first appearance. So all I'm doing is advising you that's what's happening. And am I correct that he has no Orange County cases? So that's your next step. Clinton Kudabon. This is a Hillsborough County case. Hillsborough County seeks your return there. It would either be to Tampa or Plant City. It's failure to appear for a battery, 2 counts, $2,500 per count, so a total amount of $5,000. It appears to me that if you choose to do so, or if you're able to do so, you can post a $5,000 bond here, and then it would be up to you to find out when you have to show up and where. If you take no action and you have no Orange County cases, Hillsborough County will pick you up within 72 hours and transport you to the correct location. All right. This is Charles Antoine Smith. This is a reset. Judge Carter reset it for today for a first appearance. It's 2019 MM 5124. Count 1 is resisting an officer without violence, $500 bond, and the second charge is a city charge of alcohol. There's a county ordinance violation of alcohol on a street or sidewalk. These charges come from 1404 34th Street. So that's not too far from the jail. It is it's west of Rio Grande. It should be near the interstate. The public defender is appointed to represent you on these charges, and it's in Division A. It's because these are county court misdemeanor, one misdemeanor, one county ordinance violation. Are these charges that there can be an offer at first appearances?
Yes, Your Honor. Adjudication, credit for time served.
So talk to your attorney about whether that's the best thing for you to do. What is your full legal name?
Charles Antoine Smith,
And what is your date of birth?
10/12/1988.
All right. The first charge that I have is resisting an officer without violence. How do you plead to that charge?
No contest.
And the second charge is having a possession of alcohol in an
Same.
open container, a county ordinance violation. How do you plead?
No contest.
Okay. And you know that almost every town, city in the United States has the same kind of charge. That it's not against the law to drink, but it's against the law to carry around alcohol in an open container. So that's what got you started on this particular case. Are you satisfied with your attorney?
Yes.
And did you have enough time to decide what's best for you to do?
Yes.
Okay. And count one is resisting without violence, and count two, possession of alcohol. Both of those pleas are accepted at this time. The offer from the state and the county was time served with an adjudication. Is that correct?
Yes, Your Honor.
So it's 3 days, credit for 3 days served. You'll be released later on today, but you are adjudicated guilty. And the sentence is the same for each of the two charges, but running concurrently, that is at the same time. You do have court costs, and they are payable within the next 350 days.
Okay.
Your Honor, I want to bring, I have two requests. Yesterday, we had, I believe they were going to reset a Mr. Kirk Kim, and he wasn't reset on today's docket, so I believe the state has an offer for him. He was a soliciting without a permit,
What's his last name?
Kemm.
Is this a situation where we can order him for the second session?
Yes. So I'd like to bring him in for the
Let's-
second
let's see.
session.
Let me see. Hold.
I thought she's, the JA waived it.
You had
So-
set him for a plea, yeah. I think that was his like third time or something like that yesterday.
Okay,
So
I
the judge
wasn't
waived
under
it.
the impression it was waived. She asked me if I wanted to waive it, and we said no, we were gonna go visit, but,
I don't have his paperwork in my reset stack, which means I put him as in he wasn't coming back.
okay, so.
You have to set it.
We need to set I need to email the JA and set him. Okay, can he still be set for, I'll email him quickly. He can still be set for this afternoon to plea though, right?
No.
No?
No.
We have to wait until,
Yeah, so the add-on docket is already out, so it'd have to be tomorrow. If you get her to her by 2, it can be reset till tomorrow. But you have to email to get the JA by 2 o'clock.
okay. And the second issue, we had a defendant here, and the defendant did not have a prior arrest history, and it slipped I was not thinking when she came through, she was set with a $250 bond, but I was looking at her PTR stuff, but I wanted to bring her back if it was possible. We could get an ROR. It was on a petty theft, and she had no prior history.
Not gonna RR. Is she qualifying PTR?
She did not qualify for PTR.
I'm not gonna RR petty theft.
Okay. Well then.
I'm not gonna agree to it. I'm not saying the court obviously can. I'm not going to.
I'll say this. Occasionally, I will allow an ROR or pretrial release or something like that. But the facts of that case, I felt like it should be a bond.
Okay, it was a young lady down here. Okay.
We will start the second session after a recess. How long would you like to have for a recess?
I believe Ray said 11 o'clock, Your Honor.
11 o'clock.
Okay, we'll come back at 11 a.m.
Thank you, Your Honor.
This is the second session for Thursday, June the 20th, 2019. Judge Kirkland presiding. The first case that will be reviewed is Carice Duncan. This is a warrant arrest affidavit. It is a capias, meaning the state attorney has filed an information against Ms. Duncan, charging burglary of an occupied conveyance and a petty theft charge. But the capias was issued out of Division 20 for failure to appear for a pretrial conference on June the 11th, 9 days ago. Release was revoked at that time, and the judge ordered no bond until she appears before the judge in Division 20. The public defender represents her on those charges.
Yes.
Okay, so you'll want to be in touch with your public defender in Division 20. That judge may elect to keep you on a no bond status or may set new conditions of release. Kenny J. McIntosh. This is an arrest affidavit from earlier today, 2131 Belafonte Lane. The charge is possession of cocaine. It's a felony charge. Your bond is $1,000. The public defender is appointed to represent you in Division 17. There's a co-defendant, Michael Todd Baker, that you're to have no contact with while this case is pending. There is another charge that is driving while suspended or revoked license. It's a misdemeanor charge. The bond is $500. I believe under our standards that that bond will now be $100. Your total bond is $1,100. The case number of that case is 19 CT 4596. The condition of release, in addition to the $100 bond on that case, is not to drive until your license is reinstated. The public defender represents you in Division 17 and Division A. This is Willie Eugene Miller. This is an arrest affidavit from earlier today, 5284 Long Road, Apartment A. It's in a complex entitled The Park at Victoria. Count 1 is burglary of a dwelling. The bond is $5,000. Count 2 is criminal mischief, a misdemeanor, bond $100. So your total bond is $5,100. The public defender is appointed to represent you in Division 20. Your other conditions of release: not to return to that complex, the Park at Victoria, 5284 Long Road in Orange County, in Orlando, Florida. No contact with anyone that's named or referred to in the narrative as a witness or a victim. You can now bond out on a $5,100 bond.
And Your Honor, I was going to check and see what the state. I didn't have a chance prior to court, but would you be willing to amend this to a trespass on the facts? It didn't look like he had the intent to commit a crime inside. He was just sleeping in a bed, allegedly, in the police report.
Not this time because there is damage to the window.
Okay. And Your Honor, I would make a probable cause challenge with regards to the affidavit. Based on the affidavit of arrest, it does indicate there's damage to the window, but we'd argue that the window was damaged prior to the entry, or prior, the alleged damage was done prior to the alleged entry. Once entry was made, he had no intent to commit a crime inside the dwelling. He was sleeping. He was just sleeping at the time he was identified. So we'd argue there was no probable cause for the burglary, but probable cause would exist for a trespass in a dwelling.
My rebuttal will be, I don't know if there's any information in the affidavit stating when the damage occurred to the window.
It is a question that can be raised on these kind of cases. My position is I draw a bright line between a complex that's really apartments or condominiums or any place like that, where almost all of the units are occupied by people who expect to be protected when they're sleeping at night. That situation, that factual situation, is different than an abandoned single-family dwelling, and it's clearly an abandoned house, and somebody goes and sleeps inside, that's a trespass situation. But in this case, I believe it should remain as it is. I believe it's, for me, it's a matter that can be argued later on in the case, but at first appearances, I find that it's probable cause for a burglary.
Okay.
This is Michael Nesuis. There are two charges here. First charge is possession of methamphetamine with intent. The bond is listed at $15,000. Count two is a misdemeanor charge of possession of drug paraphernalia. Bond $100. The public defender is appointed to represent you in Division 20. The case number is 19 CF 8866AO.
And he does qualify for PTR, Your Honor.
What is the state's position concerning the issue of pretrial release as an alternative to a $15,000 bond for possession?
No objection, Your Honor.
It will be the following. It will be either a $15,000 bond or pretrial release if he qualifies.
He does qualify, Your Honor.
All right.
Will you do straight PTR, Your Honor? He does want pretrial, and he does qualify.
So,
You're just saying, will you order a straight pretrial, just for paperwork
Did
purposes?
you want to order straight, just pretrial release, Your
All right.
Honor? He does qualify.
You have chosen pretrial release, is that correct?
Yes.
All right, it will be pretrial release, but based upon the type of charge involved, I will order that he is subject to random urinalysis to be certain that he is not in possession of or consuming or ingesting any substance prohibited by law while the case is pending. Tanya Rivera.
Yes.
This is a warrant that comes from Division 20 because there was an information filed by the state attorney's office charging possession of a controlled substance and petty theft. Failure to appear for a pretrial conference on May the 8th. So this is from 2 weeks ago. Your release was revoked, and the judge in Division 20 has ordered that you be held without bond till you see the judge in Division 20. Do you have an attorney on that case?
I'm trying to find out what I can do to get one because I didn't go to, I honestly didn't go to court because
Okay.
I was in I was in a program.
Okay.
I'm getting myself.
You do have the public
working.
defender, so get in touch with the public defender in Division 20 because that judge wants to see you before another step is taken.
Okay, how would I be able to find it? Yeah, because it's Miss Mejia.
Your Honor, does she have a bond right now? on
No.
that?
There's no bond till she sees the judge in
Maybe
Division
Mejia.
20.
All right, thank you.
Next case is Gregory Stewart. This is Gregory Addison Stewart. It's a, okay, do we have Gregory Stewart?
Yes.
All right. Okay, this is Gregory Addison Stewart. There are two charges from yesterday at Balboa and North Pine Hills Road. Count one is possession of a controlled substance, $1,000 bond. Count two is a misdemeanor of possession of drug paraphernalia, bond $100. So your total bond is $1,100. I've appointed the public defender to represent you in Division 22. There is a second matter In case number 2018 CF 17335, Division 15, the State Attorney's Office filed an information against you, charging you with possession of a controlled substance and possession of drug paraphernalia. The same two type of charges that are involved in the new case, but from last year. There's a failure to appear for pretrial conference on May the 1st, and so that judge in Division 15 revokes your bond, or revokes your revokes your ROR status. So you are held without bond in that case till you see the judge in Division 15. Public defender represents you on both matters, Division 22 and Division 15. This is Adam Seeley. Adam Seeley.
Yes, that's me.
This is a warrant, and the warrant refers to a date of February the 9th, 2019, so it's from several months ago.
Yes.
Count 1 is burglary of a conveyance. Count 2 is burglary of a conveyance. Count 3 is petty theft. The judge that signed that warrant set a bond of $5,000 on each of the first two charges and $500 on the third charge. So your total bond is $10,500. That may change, but that judge will have to make that decision. The judge assigned to the case in Division 22. It's case number 19 CF 8868 AO. The judge that reviewed this case had the whole file and used the affidavit to determine what the total bond should be. So if it was an on-site case, I would have set the bond differently, but this judge has the right to set the, Judge Elizabeth Starr had the right to set the bond as she saw fit and has done so. And it's a case that has 5 pages for the affidavit, so it's a complex case involving at least 2 different locations. I will also add what is appropriate, and that is no return to the locations that are shown to be where the burglaries are alleged to have occurred. One is 7600 Red Hill Trail. The other is in the vicinity of 7600 Rex Hill Trail, or 7557 Rex Hill Trail. No contact with anyone that's named or referred to as a victim or a witness while the cases are pending. You have the public defender in Division 22. This is Amber Rose Woolery.
Yes, sir.
This is a capias that has come from Division 19, failure to appear for a pretrial conference on February the 5th. The bond was revoked at that time. The original charge is grand theft, 3rd degree of a motor vehicle. So you're being held without bond till you see the judge in Division 19.
Is there a court date scheduled?
Not yet. You'll want to get in touch with your attorney to see that judge in Division 19. Do you have a private attorney? Public defender? Conflict counsel. You want to get in touch with that attorney because until the judge in Division 19 sees you, you're held without bond. You also have a misdemeanor case of petty theft, and that's in Division 62, and that's also a no bond case. Failure to appear for violation of probation hearing on December the 14th of 2018. The judge in Division 62 ordered no bond until you see that judge. So those are two independent cases that you'll need to see what can be done once the judge has a hearing for you.
Yes, sir.
Kendra Coleman. This is a traffic citation, but it wound up causing a misdemeanor charge of refusal to obey a police officer, and the bond was set at $500. Are you planning to hire a private attorney? If you are not, if you feel that you're not able to afford a private attorney and you are requesting the public defender, this would be the time to do that. I don't have an application from you. Do you recall filling out an application to ask for the public defender? I'm going to ask you some questions to see if you qualify for the public defender. There's a second case as well. That second charge is, it's an arrest affidavit from earlier this morning, possession of drug paraphernalia and possession of cannabis. Those are misdemeanors. The bond is $500 on the first charge and $100 on the second charge, for a total of $600. And then the charge of the refusal to obey is $500, so your total bond is $1,100. At the time of your arrest, did you have a permanent job?
No,
And do you own any property that you could sell to hire an attorney, such as a paid-for automobile?
no.
Okay, and what is the source? Do you live with family, or?
I live with my partner who I'm here with.
Okay. I, at this time then, appoint the public defender to represent you. That first case, which is the refusal to obey, that's in case number 19 CT 1335 AW. AW means it's a misdemeanor charge west of John Young Parkway. So you can now bond out, and you're to have no contact with co-defendant Ronald Williams.
And she did qualify for straight PTR, Your Honor.
Okay, you should talk with your attorney at this time to see whether you would prefer to be on pretrial release as opposed to posting a bond of $1,100.
She's gonna try and bond out, Your Honor.
Thank you.
Thank you.
Nicholas Edward Ingerman. There are two, Ingerman. There are two charges here. They're misdemeanors, petty theft and criminal mischief from the Walmart in Ocoee on West Colonial Drive. The total bond is $350. I've appointed the public defender to represent you. You can bond out, and you would have an additional condition of no return to the Walmart on West Colonial Drive in Ocoee while the case is pending. This is Frederick Palinsar. This is a charge of exposure. It is a misdemeanor charge from the West Entrance Drive, Westwood Boulevard, 6850 Westwood Boulevard. Are you planning to hire a private attorney to represent you, or are you requesting the public defender? Oh, the public defender is appointed to represent you at this time. You do qualify. Is this a case that can be resolved at first appearances?
No, Your Honor.
All right. You can now bond out on this case. Your bond is $500. Stavros Patsalos. This is a charge of trespass after warning from 189 South Orange Avenue from earlier today. That's the plaza. And it was for sleeping on the steps. Is this a case where it's a state charge, even though it's a City of Orlando arrest? Is the state able to make an offer to resolve the case today?
Withhold credit for time served, no return.
Okay? You should consider what is best for you. You can bond out on the case if you're going to contest it. The bond has been listed at $1,000. On the other hand, if you want to resolve the case, the offer from the state is withhold of adjudication, so you would not have a criminal record from this case. Time served, you'd be released later on today, and you'll have 350 days from today to pay the court costs. So think it over.
Yeah, I've been appointed, right, Your
All
Honor?
right.
And Your Honor, he is going to go ahead and bond out today. He's not going to
All right.
resolve.
I will order, and you're a resident of California?
Yes, yes, sir. Yes, Your
Do
Honor.
you anticipate that you will return to California and then you're going to come back to Orlando for the case at a later date?
Is there any way to go around that, or would I have to come back here?
There's no way to know.
Okay.
I'm just curious.
Yeah, if
Since
that
there's a way to resolve the case today, and you wouldn't have to come back, there's always the possibility that you might have to. I simply don't know whether you
okay,
will or
yeah,
not.
if necessary, I can come back. My only concern, Your Honor, is I don't have any criminal history at
Okay.
all, and I don't want to have this on my record, so
Okay.
that's why I just don't want to.
Well, my understanding, I'm not trying to, I just want to make sure you understand all the options.
Of course.
My understanding of the offer was a withhold, is that correct?
Correct. However, if somebody runs his criminal history, it'll be on there.
So no matter what you do, if you're asked a question like on a job application, have you ever been arrested? Yes, you have, and there's no way to get around that.
Yeah.
But you won't have been convicted of anything because the offer is to withhold adjudication. So you've not been convicted of a crime if you decide to resolve it today. I'm just pointing that out as an
Okay.
option. Why don't you talk to the attorney and see, I just want to make sure you're taking the option that you think is best for you.
Of course, I appreciate that, Your Honor.
Mr. Wynn?
Yes. I
All right.
Mr. Wynn?
Thank you very much. Thank you.
The next case is Alcides Pelo Hernandez. All right. Ronald Williams. This is an arrest affidavit from earlier today, East-West Expressway. Possession of drug paraphernalia and possession of cannabis. It's a bond of 500 plus 100 for a total of 600. I don't have an application from you. Are you planning to hire a private attorney?
No, I object.
Are you asking for the public defender?
No,
You're going to represent yourself?
I'm going to present myself.
Okay. Is there an offer by the state at first appearances for a pro se defendant?
Either no objection to ROR or an adjudication as to count 1, withhold as to count 2, credit for time served.
Okay, you have an option, you can bond out on a $600 bond, or if you choose to, does he qualify for pretrial release?
He does, Your Honor.
And
Okay.
state had no objection to ROR, Your Honor. ROR, releasing his own recognizance based on the cannabis and paraphernalia charges.
I also wish to resolve this.
You want to resolve it?
Yes.
Okay. The
under the-
offer is, there would be a withhold of adjudication on the cannabis charge, and there would be an adjudication on the possession of paraphernalia. And the reason for the withhold is that, so you don't lose your driver's license. So see if you feel like that would be worthwhile to accept that offer. And it would be time served and court costs?
How about I'm willing to plead guilty under the conditions that rule of discovery is disclosed?
You probably would want to enter a plea of no contest.
No contest?
Is that what you think that's best for you, to enter a plea today and resolve it today, be released later on today?
Affirm.
You'll need to read and sign your plea form at this time. What's your full legal name?
My full legal name? The name is Ronald Ivan Williams,
Okay.
for the record.
Spell your middle name.
The middle name of Ronald Ivan Williams is spelled I-V-A-N,
All right.
for the record.
They only have you here as Ronald Williams, so I just want to make sure. And date of birth?
That's clear.
Date of birth?
The date of birth for the record is 11/17/1985, for the record.
All right. How do you plead to the charge of possession of drug paraphernalia?
Guilty.
How do you plead to the charge of possession of cannabis?
Guilty.
Did you read and understand your plea form?
Affirmative.
Do you have any questions you want to ask me concerning these charges, the facts of the case, the plea that you're entering, or the proposed sentence?
Yes. Can you clarify the appeal time period?
The what?
The time period to present an appeal.
You want to appeal?
In the event I want to appeal, what is that time period?
It would need to be in writing within 30 days.
Thank you. That'll be all.
The pleas are accepted at this time. You're adjudicated guilty on count 1, possession of drug paraphernalia. The sentence is 1 day, credit for 1 day served. Count 2 is a withhold of adjudication on the charge of possession of cannabis. 1 day, credit for 1 day served, running concurrently. That is at the same time. You'll be released from jail later on today. You will be responsible for the court costs in the case, and those court costs are to be paid within 350 days from today. You have the right to appeal this sentence within 30 days in writing.
Accepted.
Jacob Chambers. This is a hold for St. Lucie County. Ordinarily, it'd be the courthouse in Port St. Lucie. It indicates it's for criminal mischief. So you can bond out here if you decide to do so. The bond's $250. If you bond out here and you have no local charges, then it's up to you to find out when your next hearing is and show up at the right place.
Okay.
there may be more than one courthouse, for example. I don't know if it's Port St. Lucie and Hutchinson Island or whatever. If you do not, and you have no local charges there to pick you up within 72 hours, and they'll transport you to St. Lucie to see the judge concerning that charge.
Okay.
Any questions about that charge? Okay. Oscar Tyrone Johnson.
Yes, sir.
This is a city ordinance violation of having an open container. Almost every city and town in the United States has the same law. It's not against the law to drink, but it's against the law to have an open container of alcohol. And the public defenders appointed to represent you in this case is case number 19MO1172. And this case is from 648 West Washington Street from last night about 11 o'clock at night. There may be an offer from the city to resolve this case.
Adjudication, credit for time served.
If he decides to resolve the case, I will lift the hold. It indicates he was out on bond on another case at the time last night.
Yes, sir.
And he is going to enter a plea of no contest.
What is your full legal name
Oscar Tyrone Johnson,
and your date of birth?
9177, September 1st, 1977.
The charge is open container of alcohol, a city ordinance violation from last night at about 11 o'clock at night. Sitting on a wall drinking alcohol. How do you plead to that charge?
No contest.
Did you read and understand your plea form?
Yes, sir. Yes,
Any
Your Honor.
questions you want to ask me concerning the charge, the facts of the case, the plea that you're entering, or the proposed sentence?
No, sir.
Okay. And you understand that basically you just need to find, in the future, find someplace inside to drink, not outside?
Yes, sir.
Okay. I take no action on the prior case, and I lift the hold. He's no longer being held on that matter. You are aware that you have a felony charge. You need to keep in touch with your public defender.
Yes, sir.
And it looks like your next hearing is June the 26th. So make sure you know where and when to go to that hearing.
Okay.
All right? It's on a serious felony charge. The sentence on this case is adjudication time served. 2 days, credit for 2 days served. You'll be released later on today. You have court costs in this case, and those court costs are on in a civil judgment at this time. Okay, we return to the case of Stavros Patsalos.
All right, thanks.
Your Honor, can I do the pre-trial diversion? I'm sorry. I don't know.
I explained to him that he might have an opportunity for pretrial diversion in the future, that he didn't have an offer today, but that was something that could be pursued in the future, in which case,
Okay, and would that be a possibility?
Yes, Your Honor, he has no criminal history that we see.
Okay. And so, is it your decision today that you feel the best thing for you to do is to bond out? You're gonna post a
Yes.
bond?
Yes, yeah,
Okay.
I have to get back to work.
Okay. And you're from San Pedro?
Yes, sir.
And is that in Silicon Valley?
No, it's 30 minutes south of downtown Los Angeles.
Okay.
Yeah.
Okay. All right.
Bond is pending, Your Honor.
Okay. And bear in mind, the way I look at these kind of cases like you've got, I mean, there's a place when somebody's sleeping on a doorway downtown, there are worse places that you can wind up, like the hospital or the morgue,
course.
than coming to jail.
Of course.
And so sometimes all they're doing is trying to keep everybody safe, okay?
Understand.
So keep that in mind.
Understand. Thank you, Your Honor.
Okay, I think that ends the second session.
Yes, Your Honor.
I will be back on Monday and Tuesday. Someone else will be here tomorrow. Court's in recess.